All persons having business before the Honorable Associate Judges, now presiding of the District Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please come to order.
Thank you. Good morning. We have 3 cases on the calendar this morning. We'll take them in the order that they are in. The first case is Melinda Dennis versus Patrick Jackson. Counsel, you may proceed.
Good morning, Your Honor. My name is Ray Shepard. I'm here on behalf of the appellant, plaintiff below. I'd like to reserve 5 minutes in rebuttal if I may. Your Honor, I'll begin with the parties' dispute over the appropriate standard to be applied by this court in review. I first point out to the court that the Superior Court clearly was working under the familiar summary judgment standard. If you look at the court's order, which appears at page 423 of the appellate record, at the bottom, she's clearly referencing the summary judgment standard. And also in the statements made from the bench, which appear in the record at page 436 and 437, at the bottom of 436 up to 437, the court is reciting the summary judgment standard that she's attempting to apply. In addition to that, the parties agree that this court's most recent pronouncement or case in which application of judicial estoppel was applied to a personal injury action is the case of Atkins versus 4940 Wisconsin LLC. The parties differ a little bit about what standard of review the court applied in that case. On page 1289 of the opinion, which appears at 93 Atlantic 3rd 1286. So again, at page 1289 of that opinion, the court says, and I quote, "We reviewed de novo Mr. Atkins's claim that the trial court erred in granting summary judgment in favor of the LLC." The court also in Atkins makes reference to another 2014 decision which applied judicial estoppel. That's the case of Ward versus Wells Fargo. Both of the parties have cited that case as well. And at page 126 of that opinion, which is at 89 Atlantic 3rd 115, page 126, again, the court states, "We reviewed de novo the trial court's grant of summary judgment." So in the court's 2 most recent pronouncements of cases dealing with judicial estoppel, it appears clear, at least from my perspective, that we're dealing with the familiar summary judgment standard. However, I think the parties both may be correct. It does appear that there is, when applying judicial estoppel, it's clearly indicated to be an equitable remedy, which is in the discretion of the trial court. But I would suggest to this court that before you get to that, you must have an undisputed foundation of facts that support the court's discretion to exercise judicial estoppel. In other words, I think you have to have both. Moving on to the substance of the case, there are 2 issues that we are addressing on appeal. The first, Your Honor, is in every case, and I've cited them in my brief and I won't go through them now, but in every case decided by this court that I could find after the case of Maine versus New Hampshire in 2001, which identified 3 factors for the proper application of judicial estoppel. In every case since then, this court has followed the main, I call them the main factors in my brief, but they're the factors identified by the U.S. Supreme Court in that case. I'm going to focus on the 3rd factor because that's the one that I believe that the court erroneously found in this case. And if you want to apply abuse of discretion standard, it was an abuse of discretion to find that 3rd element. In the Atkins case itself, when dealing with the 3rd element, it was quite obvious that the plaintiff, Mr. Atkins, had gained an unfair advantage, which is the 3rd main factor, an unfair advantage or detriment over the opposing party. And that's where the dispute is in this case, whether it has to be over the opposing party. I suggest that it does have to be over the opposing party. Otherwise, there's an insufficient connection between the bankruptcy and the underlying action to support such a drastic remedy as judicial estoppel. In Atkins, this court indicated that the third element of the main factors, or the third main factor, was satisfied because Mr. Atkins's discharge included 99.7% of the amount that he was seeking in the underlying action, in his personal injury action. Almost all of that had been discharged, and so he was really seeking to double dip. He got the discharge, plus he was trying to then obtain the same damages against the defendant. My reading of Atkins is that it's fully consistent with the Supreme Court's decision. The Superior Court below found support for her position that, well, I should clarify, none of the defendants below were creditors in the bankruptcy. So not a single penny of what was discharged was owed to either of the two defendants in this case. That was clearly not the case in Atkins. In dealing with that issue, the Superior Court found support for her position that you don't have to have the defendants be creditors in the underlying bankruptcy in two federal cases. She relied on Moses and Robinson, which are cited in the briefs. But both of those cases, Your Honor, involved overlapping claims at the time of the bankruptcy, which is not the case here. So in Moses, you had two pending bankruptcy cases that were still active when the plaintiff filed the underlying lawsuit. And he did not disclose that when the cases were both existing simultaneously. And
Mr.
there,
Stepper, if I may interrupt you,
of course.
do you read the test in New Hampshire versus Maine as actually saying that the plaintiff must gain an unfair advantage over the opposing party?
I do.
Because I don't really read it as saying that.
Well, the Supreme Court clearly states in the opinion that Maine obtained an unfair advantage over New Hampshire.
It did.
Or I may have it backwards.
Or it was to the detriment of New Hampshire.
Right, because of the prior, I think there was a prior settlement and also a prior.
But I don't see why you read New Hampshire as, why you read New Hampshire versus Maine as necessarily requiring that. It seems to me that in this case, the argument is that Ms. Dennis obtained an unfair advantage in the bankruptcy proceeding because she did not make her creditors in that proceeding aware that there might be this claim bringing in some money that could pay her debts to them. And the purpose of the judicial estoppel doctrine is to protect the integrity of judicial proceedings and to encourage people very strongly not to withhold information in them. So why shouldn't we apply judicial estoppel here? Or to put it a little bit more precisely, why do you think the judge in the trial court here exercised her discretion erroneously in applying judicial estoppel?
Okay, Your Honor, in response, I think everyone agrees that judicial estoppel is a pretty severe sanction and it ends the entire claim. It's supposed to be an equitable remedy, and courts have indicated that in order to properly apply such a sanction, you need some connection between some advantage that you're gaining by the non-disclosure previously. So, well,
we know exactly what advantage she gained. She gained the advantage of not having her creditors in the bankruptcy try to look to the potential recovery in this lawsuit against her doctor in the hospital.
But you also have, Your Honor, the timing of that, which brings me to the second issue, which I should probably get to, because I think it's the one that you should rule on. But here you don't have overlapping. I see what you're saying, Your Honor, but there's such a distance between the bankruptcy and this claim that it seems to be an overly harsh penalty when you file a claim a year later that you weren't even that was a thought in your mind that you hadn't pursued at all. I understand that eventually she did pursue it, but
well, the key point is she intended to pursue it at the time that she was in bankruptcy.
Well, potentially. She said yes, potentially, and she testified that if she failed to do that, which takes me to the second issue, which was whether or not there was a material dispute of fact. Now,
before you get into that second issue, can I ask you a question about this third factor from the third main factor, as you term it? Your reading is that there must have been an unfair advantage over the opposing party for judicial estoppel to lie in this case. And your opponent argues, and I'm not sure I can get the argument quite right, but I think you'll know what I'm talking about. Your opponent argues that there was an unfair advantage over the defendants, even if that is required here, because they might have, had the claim been made known to the bankruptcy court and to the creditors in that case, they might have been able to negotiate a favorable settlement that would have paid off the creditors and maybe saved the defendants some money. It's not entirely clear to me how they would have been able to do it, but that seems to be their point. So I guess what I want to ask you is whether you understand the point, and if you do, what's your response to it?
I do understand the point, and I think that if you were to follow that argument to its logical conclusion, every case in which you have a bankruptcy and a non-disclosure like this one, no matter how unconnected it is, you would satisfy that standard, because any case could be, in theory, settled. But this is a complex medical malpractice case, which has a lot of prerequisites before you can even file the suit. So the argument that a trustee would have been in position to settle a complex medical malpractice case had it been disclosed on the schedule, I think is not something that would happen in the real world. It's just too hypothetical or ethereal, I say in my brief, to satisfy the main standard. And I do believe that each time this court has recited the main factors, and if you look at page 1290 of the Atkins decision is a perfect example. The court quotes the third main factor as follows: whether the party seeking to assert an inconsistent position would derive an unfair advantage or impose an unfair detriment on the opposing party, if not estopped. And I think that that's important language that the court didn't just insert because it felt like it.
Yes, but Mr. Shepard, take a look at that language. It does talk about imposing an unfair detriment on the opposing party, but it doesn't say the alternative. The lead-in is or. The alternative is deriving an unfair advantage. You don't derive an unfair advantage on an opposing party. The key point is that Ms. Shepard here, and the Supreme Court doesn't say you have to, in some way, gain the advantage at the expense of the opposing party. The Supreme Court here seems to be saying, and case law, as you know, says that it's enough if the appellant, by withholding the information about the plaintiff, by withholding the information about her claim, gains an unfair advantage in a judicial proceeding. And there seems to be no question but that the trial court here could find that Ms. Dennis did gain an unfair advantage for the reasons we've talked about. And I'm waiting to hear you say, or to hear you explain why you think or in what way specifically you think the trial court here abused her discretion in applying the doctrine of judicial estoppel. It's not enough to argue and say the trial court could have come to a different result. You've got to show that there was an abuse of discretion here, either because she misunderstood the law or because she misapplied the facts in some serious way, or because she didn't consider some relevant, important factor that she was asked to consider. That's where you have to be addressing us, I think, in this circumstance. I'm assuming, for the sake of argument, that the defendants here did not suffer any unfair detriment as a result of Ms. Dennis's failure to disclose the claim against them in the bankruptcy. I don't think that's the end of the inquiry, though.
Your Honor, to answer your question, the last question by the other justice, I think, hit the nail on the head, because the Superior Court found that could be satisfied because of the hypothetical possibility that the trustee could have settled this medical malpractice claim, and therefore the third main factor was satisfied. That's ridiculous. There's no way that a bankruptcy trustee, based solely on a disclosure, because all that she would have had to say is that I'm planning a potential complex medical malpractice case. There's no way that a trustee is going to be in a position to settle that type of claim in the context of a bankruptcy. Now, you can say that in every case, but I think that if you want to apply abuse of discretion as to whether those main factors were satisfied, I think that's an abuse of discretion, because it's just not going to happen in the real world. But I think I need to get to the second point here, because I think it's really important. We still have a grant of summary judgment here, and we are all familiar with the requirements before you grant summary judgment. The court is not supposed to weigh the testimony or determine who's right or who's wrong, only whether there's a dispute over a material fact, and we have that here. The Supreme Court in Maine and also this court has made it very clear that judicial estoppel should not be applied when the disclosure is a result of mistake or inadvertence, as opposed to an intentional attempt to mislead the courts. And here you have conflicting testimony. You have Miss Dennis testifying that if she was supposed to disclose it, it was a mistake. You also have her declaration indicating that she had conversations with her attorney, and she was under the understanding, rightly or wrongly, that in Maryland, any claims for personal injury would be exempt anyway. And as you know, there are many cases that say if you don't have a motivation to lie, then then it's more likely to be as a result of a mistake, which is what she testified to. The Superior Court took that testimony and assumed only a negative inference. That was improper. She was required to remain neutral. She wasn't supposed to be deciding the credibility of witnesses at that stage on summary judgment. I could draw just as easily from the same testimony a favorable inference, and that is if Mrs. Dennis didn't have an obligation or didn't have an understanding that at the time she didn't list her potential case a year down the road, if she believed that it wouldn't matter anyway because any recovery would be exempt, then what motivation did she have to lie in the bankruptcy court? The answer is little to none. That evidence should be heard by a jury. It was improper for the Superior Court to decide that matter as a matter of law. And you can say that this is a discretionary, that judicial estoppel is discretionary and it's an equitable remedy. I can grant you all of that, but you still are dealing with a grant of summary judgment here where there's a dispute over a material fact. If a jury finds that Ms. Dennis made a mistake, and because there was a year between the time that she filed for bankruptcy and when she ultimately brought this case, that she didn't understand that for whatever reason, could have been on the advice of counsel, could have been that she was just ignorant. But if a jury believes that that's the case, judicial estoppel would not be applied. And that's a material fact.
I have to interrupt you because I want to follow that particular point before I forget about it.
Yes, Your
How
Honor.
does a jury ever get involved in determining equitable remedies and equitable questions?
Well, the question would be a factual one. The issue here is whether the Superior Court, I guess, abused their discretion when there was a dispute over a material fact to grant summary judgment on the basis of judicial estoppel or any other basis. The jury would be the fact finder to determine, really we're talking about Ms. Dennis's motive and intent. This court has said that when you're dealing with issues of motive and intent, very rarely should those issues be decided at the trial level, on a motion for summary judgment. What the jury would have to decide is, did Mrs. Dennis intentionally fail to disclose her potential lawsuit to gain an unfair advantage or to place a detriment on the other side? Or was it simply a mistake, a legal mistake, a blunder, something that she did unintentionally?
Mr. Shepherd, have you found any case in which the question of judicial estoppel was left to a jury?
Yes, and I cite 3 of them in my brief. If you look at the end of my brief, Your Honor, you're going to see Access Limousine, which is a District of Maryland case, 2016. You will see Ryan Operations, which was a 3rd Circuit case. And you're going to see an 8th Circuit case, I believe, called Eubanks. In each of those decisions, the court found that because there was a dispute over a material fact, and it was the same material fact, whether or not the disclosure was intentional or unintentional, that's the fact. The court rejected application, the lower court's application of judicial estoppel because of that dispute over the material fact. So if the defendants want to argue to the jury
Is that a case in which the question of judicial estoppel was left to the jury?
Well, your language of leaving judicial estoppel to the jury, I think, is a little.
Well, the finding of the facts to decide the question of judicial estoppel.
Yes, in each of those cases, judicial estoppel was not permitted because there was a dispute of material fact for the jury to decide as to whether or not there was an intentional non-disclosure or an unintentional disclosure. And everybody agrees, I think, and you can certainly ask Ms. Ferrero when she gets up, whether if it was in fact found to be unintentional, it would be an abuse of discretion to apply judicial estoppel.
Okay, now let me, I take the point. You've asked us to reserve 5 minutes for rebuttal.
Thank you, Your Honor.
And so what we're going to do is hear from Ms. Ferrero, and then we'll return to you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court, Janet Ferrero on behalf of MedStar Georgetown University Hospital and Dr. Patrick Jackson. I think, Your Honor, Judge Glittman is absolutely correct. The standard of reviewing the application of the doctrine of judicial estoppel is clearly an abuse of discretion standard. I also would point out, Your Honor, that you are absolutely correct that this doctrine, this equitable doctrine, is not one to be put in the hands of a jury. Rather, it is a doctrine to be decided by a judge equitably. There is no evidence in this case. There's no suggestion in this case. If we look at appellant's first brief, initial brief, that the argument isn't even made that Judge Wingo abused her discretion. And in fact, she did not abuse her discretion. This was not a single quick ruling. This was briefed over 2 years, 2 full years, and she considered and reconsidered. I would point the court to the transcript, which is in the abstract at pages 281 to 316, where there was a back and forth on the exact issues that Mr. Shepard just addressed. And then there was further briefing, and then the court rendered its opinion in 35 pages of well-reasoned opinion, found in the abstract at 425 to 459. She went through each of the elements, and the first 2 elements in Maine were conceded. And so she focused on whether there was an inconsistent position that would derive an unfair advantage. Judge Glickman, I think you're 100% correct. The standard there for that third element is there an unfair advantage, or does it impose an unfair detriment on the opposing party? And I understand, Judge Glickman, that you in particular are assuming for purposes of this argument that there was no imposition of an unfair detriment on the defendants. But there certainly was an unfair advantage over the creditors. And I don't mean to be conceding the latter point, but just stressing the first one, since it is an either or.
But you do make in your brief this argument about settlement, and the trustee could have settled so that there was an unfair advantage to your clients. Could you explain that point? Because as you heard, Mr. Shepard thinks it's a ridiculous point, that this wouldn't have happened in the real world.
I do understand Mr. Shepard made that argument. The point is simply, Mr. and Mrs. Dennis filed for bankruptcy and sought to wipe out $86,000 in debt. If the trustee heard that there was this multi-million-dollar potential lawsuit out there that they could tap into to satisfy those innocent creditors, would they ignore that? Or would they reach out to MedStar Georgetown and or Dr. Jackson and say, there is this potential multi-million-dollar lawsuit that Mrs. Dennis not only thought she might consider, but was absolutely certain she would file before she ever filed her application for bankruptcy? Would the trustee ignore that fact? Absolutely not. That is a potential asset they would tap into. And would a multi-million-dollar lawsuit have been resolved for $86,000? Who knows? But it certainly seems that it might have been something Georgetown would consider, certainly something the trustees would want to do, and certainly would be more beneficial to the creditors than wiping out $86,000 of debt that was owed to them. And so, Your Honor, that's how that doctrine would come into play with the unfair advantage on the defendants. But again, you don't need both, because the creditors were disadvantaged here because they lost the opportunity to tap into $86,000.
In Miss Dennis's lawsuit against the hospital and Dr. Jackson, did it get to the point where she had quantified any of the damages that would not have been exempt in the bankruptcy proceeding?
She claimed a lost wages, claiming that she would have gone back to work as a nurse. Was that quantified by an expert witness at the stage of the litigation? No, but certainly it is generally accepted what a nurse's salary is. She also had pre-petition medical expenses that were in the $100,000 range or more than that had already been exchanged between the parties. So there was plenty of money there that would not have been exempt to satisfy those creditors. And on top of that, Your Honor, she was claiming punitive damages. And I recognize the punitive damage claim was dismissed in the midst of these arguments over judicial estoppel. But I would argue that that is a little too small, a little too late, because the ad hoc attempt to fix what was essentially a fraud on the court is too little too late. Your Honor, with regard to the inadvertence or mistake, the court considered this, and the court recognized that appellate courts, including this court, have very narrowly interpreted that inadvertence requirement. So first, if the party lacked knowledge of the undisclosed claim, that's not the issue here, but it could be inadvertent under that circumstance. Mrs. Dennis testified in her deposition that she knew of the claim. She declared in her affidavit that she knew of the claim, that she discussed it with her lawyer, and that she made a conscious decision not to list it. Whether her lawyer's advice was good advice or bad advice, it was considered, and she made the choice. The second possibility for inadvertence would be if there was no direct motive for concealment. And Judge Gutman, I think you addressed her direct motive for concealment. She could wipe out $86,000 of debt and then pursue a malpractice claim where she's seeking tens of millions. So there's certainly motive for concealment. And Judge Wingo considered each of those facts. So that's the most important point. She considered whether there was a motive for concealment, and she did not abuse her discretion in finding there was. And she considered whether this was inadvertent, and she did not abuse her discretion in finding that it was not inadvertent. There's no dispute she knew about her claim. I'm sorry?
Mr. Shepherd, I'm sorry, I apologize. Go ahead.
There's no dispute that she knew about her claim, that she concealed it to the bankruptcy court, and that Judge Wingo considered each of those factors and found that the application of judicial estoppel was appropriate. She did not abuse her discretion here, and it's not for this court or any other court or for Mr. Shepherd to say they would not have reached the same determination. The question is, did she abuse her discretion? She exercised her discretion. She exercised her discretion after considering over 2 years. I'd ask the court to affirm the decision of the lower court. And if there are no further questions.
Well, in finding a lack of inadvertence, did Judge Wingo decide a question that should have been put to a jury?
Not at all. Again, this is an equitable doctrine. And the
Well,
issue,
certainly it's an equitable doctrine. Judicial estoppel is, and whether to apply it is a decision for the court. But if its application depends upon a finding of inadvertence or not, let's say, is that an issue that has to be decided by the jury, or is this the case? Would you maintain that this is a case where no reasonable jury could find inadvertence, and therefore the court could, as a matter of law, find that it was not inadvertent?
I maintain, Your Honor, that Ms. Dennis admitted that it wasn't inadvertent. She said that she had knowledge of her undisclosed claim before she filed for bankruptcy. And she admitted in her affidavit or declaration, one or the other, whatever it was called, that she talked about this issue with her attorney in bankruptcy. So there was no inadvertence here. She clearly knew what she was doing. She made a conscious decision. And as Judge Wingo said, at the end of her decision in 2018, there are consequences for that conscious decision.
The focal point, though, that I think Judge Thompson and I, too, want you to focus on is this. Mr. Shepherd is arguing that if there was a factual dispute here over the question of mistake or inadvertence, then even though the decision on judicial estoppel ultimately was for the trial judge to make, the trial judge should have left the fact finding on the questions of mistake and inadvertence to the jury. And he says that he has cited 3 cases in his brief that stand for that proposition. Do you agree with him?
No, Your Honor, I do not. I think Mr. Shepherd has misinterpreted those 3 cases, and I don't believe there is a case in the United States where issues were considered factual disputes in an equitable setting, such as judicial estoppel. But again, I don't think there's any dispute because I think Ms. Dennis was very clear in what she knew and what she intended. Did she intend to wipe out a multi-million-dollar medical malpractice action? No, she intended not to disclose it. She didn't disclose it, even though she considered disclosing it, talked about it with her bankruptcy lawyer. So I think those 3 cases stand for a different proposition. None of those 3 cases were decided within the District of Columbia. And again,
Is it correct, by the way, she never actually explained why she did not include the claim, did she?
She did in her affidavit or declaration, which is in the abstracts. She says she discussed it with her attorney and made the decision not to. Now,
Right, she said that, but she never actually explained why she made that decision.
She did not. She did not.
I mean, I'm not saying she should have, but she hasn't disclosed what her attorney told her. She hasn't actually given an explanation for, she hasn't actually said, I thought this was not required to be disclosed, let alone.
She does, in fairness, say in her declaration, I thought it was exempt. But
Right,
again,
she thought the claim was exempt. She thought the proceeds of the claim would be exempt from her attachment by her creditors. But that doesn't answer the question of why she didn't disclose it. She was asked to disclose claims where it's not for her to decide, oh, I'll only disclose the ones I think are exempt or not exempt.
I agree, Your Honor.
One of the things your opponent says, I believe, at the close of his brief is that the application of judicial estoppel in this case was too severe an equitable remedy or sanction, that the forfeiture of the claims is too severe. And he suggests that there is a case out there where a court fashions some other kind of a remedy, something short of a complete forfeiture. It kind of calls to mind the phrase about equity abhorring forfeitures. Is there some other equitable remedy in this case that the court should have considered short of judicial estoppel that just foreclosed the claims altogether?
No other equitable remedy was suggested in the court below by either the plaintiff or defendant. And so an issue not raised in the court below, as Your Honor knows, is not properly before this court. But moreover, the question we come back to is, did Judge Wingo abuse her discretion in determining that application of judicial estoppel was the appropriate remedy? She considered the facts. She outlined in depth the law. She read every case and said that in her opinion, and then she applied the equities. So did she abuse her discretion? I suggest not.
Okay, counsel, thank you. We have your argument.
Thank you.
And we will now hear from Mr. Shepard. Mr. Shepard, you reserve 5 minutes for rebuttal.
Thank you, Your Honor. First, to the last point made regarding whether Calafiore which is the case being discussed about the alternate remedy, whether I raised that below. I most certainly did. And in fact, in the order, Judge Wingo cites to that case, which is at page 423 of the record, 418 Fed Sup 2nd 795. And that's because I raised it below. But there's Miss.
What's the site again, please?
I'm sorry, Your Honor. It was it's 418 Fed Sup 2nd.
No, not the guy. Where did I know the case? I meant where did Judge Wingo? Where did Judge Wingo cite that case? She cites it in her order at the appellate page 423, Your Honor, 423. Thank you.
Ms. Ferrero just said that I misread the 3 cases cited at the end of my brief. I'd like to quote from those cases. In the Access Limousine case, which is cited at page 26 of my brief, this is a District Court of Maryland case, 2016, in which the court denied summary judgment because, quote, the facts and circumstances in the record to date establish a genuine issue of fact whether Access intentionally concealed the negligence claim from the bankruptcy court or did so inadvertently or by mistake. I don't think I'm misunderstanding that. And the second case I'll quote from is the Eubanks case. That's a Sixth Circuit decision from 2004, in which the Sixth Circuit declined to allow judicial estoppel to be applied because of omissions on bankruptcy forms, quote, that might be inadvertent, such as where the debtor lacks knowledge of the factual basis of the undisclosed claim or where the debtor has no motive for concealment. I think that latter statement is of critical importance in this case because this was a Maryland bankruptcy, not a District of Columbia bankruptcy. And they are different because in Maryland, you have a much larger exemption for personal injury than you do in the District of Columbia. In DC, I think it's limited to 26,000 or something like that. In Maryland, it could be anything. And so that is not a difference without significance or relevance.
Counsel, I have a question. Let me just interrupt. You focus on the non-exempt character of a personal injury claim or proceeds from that claim,
Yes.
but didn't the complaint also include demands for damages that were not exempt, such as lost wages and other things? What about not reporting that aspect of the potential lawsuit?
Your Honor, that's a very good point. And when I was attempting to apply well, not apply, but follow the Calafiore decision from Maryland, I recognized pretty quickly that certain things were exempt and certain things weren't. I filed the amended complaint in an attempt to eliminate the things that were not exempt. I didn't quite accomplish the goal as completely as I should have, but I eliminated punitive damages, for example, and I should have eliminated I think it's either past or future wages. Not both, but one of them is not exempt. You're exactly correct. And so, I mean, if this court were to say, as the court did in Calafiore, you can't pursue any damages claims that were not exempt in the Maryland bankruptcy, that would be an equitable result, because you wouldn't be entirely eliminating meritorious claims. Even the court recognized that the underlying medical malpractice here, if proved, is both serious and debilitating for my client. To say, and you know, the only overlap is I think $320 of co-payments to a third party for wound dressings was the only thing discharged that has anything to do with this case. And to me, if you are talking about an equitable remedy, what is equitable? Is it equitable to eliminate the entire claim because a year before you filed your lawsuit, you forgot to put it on the bank, or you either forgot or you thought it wasn't necessary because of what your lawyer told you or because of your understanding that it was exempt? That's a factual finding that the jury should be allowed to make, not the superior court. And that, I believe, is the reason to send this case back to the superior court and let the jury decide whether this was inadvertent or intentional. In the cases where the court relied on the federal cases of, I think it was Moses and Robinson, you didn't have to. The issue was clear because you had the bankruptcy and the underlying actions were in existence at the same time. It was clear that there was a non-disclosure and it had to be intentional because the case was already in existence. So in Moses, you had two bankruptcies at the time the lawsuit was filed. And in Robinson, you had two EEOC complaints in existence at the time the bankruptcy was filed. So it's completely unlike this case. And to say that you could decide that issue of motive as a matter of law, Your Honor, it's error. It's any way you sliced it, it's not what's supposed to happen at summary judgment.
Counsel, I think that
I use my time, Your Honor.
well, why don't you bring yourself to bring your remarks to a close?
Yeah. So I did bring Calafiore to the court's attention below. It is for this court to determine what is equitable, and in this particular case, I would ask the court to fashion an equitable remedy. I mean, we're not seeking to take advantage of the bankruptcy court. And neither is my client. She's willing to give up whatever claims that
you understand that your client giving up claims does nothing for the creditors in bankruptcy.
Your Honor, the idea that that a car dealership or somebody who had a few $1,000s discharged, I understand that in theory, the bankruptcy could have taken control of a medical malpractice claim, gone out, hired an experienced medical malpractice attorney, pursued the claim for the 5 or 10 years that it takes to get through one of these cases, which not to mention has a lot of costs and expenses associated with it. I just don't think that that's really going to happen in the real world. I haven't found a single case where a medical malpractice claim was disclosed in a bankruptcy petition and then the trustee pursued it. I'm unaware of any. I haven't found any. And I'm not saying I'm the best researcher in the world, but I have access to
There are other ways of dealing with it besides having the trustee pursue the claim.
That's true. But the idea that you're going to settle such a claim and that therefore, the creditors were somehow harmed is, I think, not a realistic view. And if you take that view, then every single claim where there's a non-disclosure in a bankruptcy, every claim could be, in theory, could be settled, no matter how complex. So you're creating a bright line rule there that if that's the case, Katie barred the door because it's a bright line rule. And I just don't think that's equitable. And we're dealing here with an equitable remedy. So thank you, Your Honor, for listening.
Counsel, thank you both. The case is submitted.
Thank you, Your Honor.
And you may log off now.
Thank you.
We will now call the second case on the calendar. Enrique Menendez versus United States. We don't have the video yet. Ms. Terrell, I'm sorry we're keeping you waiting because we're waiting for the United States to come in.
No problem.
Okay, Judge Glickman, she's joining. I don't know what's taking so long, but she's coming.
Thank you.
Okay, here she comes, Judge Glickman. Okay, all right.
Thank you. Okay, we have, Ms. Kelly, we have called the case of Menendez versus United States. Counsel, you may proceed. You'll have to unmute yourself, however.
Sorry about that. Good morning. Fleming Terrell on behalf of Appellant Enrique Menendez. I'd like to reserve 2 minutes of my time for rebuttal. Had the defense known that the prosecution had 14-year-old witness DT's father arrested to compel him to bring DT to the district to testify, it would have been entitled to confront DT with that arrest and the circumstances leading up to it, to probe his bias to curry favor with the prosecution. By suppressing that information, the prosecution kept the defense from conducting what could have been a powerful impeachment of the only witness to directly corroborate any of complainant CG's allegations of abuse. The possibility that such an essential witness could have been discredited in the jury's eyes undermines confidence in the outcome of the trial. The result is a material Brady violation that requires a new trial. The circumstances of the arrest of DT's father amply satisfy the lenient foundational requirement for a bias cross. All that's required is a well-reasoned suspicion, that is, a credible statement describing the suspected cause of bias, supported by plausible factual allegations, or itself plausible within the framework of facts that neither party has contested. Here, those facts include that DT's father and sole caretaker emphatically refused to bring DT to testify, that he was arrested and held for 5 days over a holiday weekend, and then released on the condition that he cooperate with the prosecutor in arranging travel to the district to bring DT to trial, and he in fact did so. From these facts, it's entirely plausible and reasonable to conclude that DT noticed his father's jailing and either heard or figured that it related to his father's sudden decision to bring him to testify, and that display of overwhelming prosecutorial power from thousands of miles away frightened DT enough to provide him a bias to curry favor with the prosecution. So notwithstanding the handful of cases that the government cited about material witness warrants, this court has never held, nor could it, that a material witness warrant cannot be biasing, because there's binding precedent in this jurisdiction that a witness's subjective belief is what creates the bias. And it's entirely reasonable for a witness whom the prosecutor has jailed in order to compel their testimony to believe there could be further repercussions if that testimony is not satisfactory. The likelihood of such a belief is only increased when you're dealing with a 14-year-old witness who's seen his father jailed over trying to protect him from coming to court. In addition, there's this 3-year background of the prosecution pressing DT's father becoming very emotional, refusing repeatedly to cooperate, being threatened with arrest, all the while having discussions with DT about whether to testify at trial. All of that just adds more heft to the inference of bias, that DT would feel threatened by the prosecutor's persistent efforts to overcome his father's will, culminating in his arrest. So because all of these facts amply support a suspicion of bias, the defense would have had the right to inquire. And DT's answers and his demeanor while answering, even if he denied knowledge or bias, could have led the jury to infer bias to curry favor and therefore to discredit him. There's no question that the prosecution had this information and that it failed to disclose it to the defense. And that suppression is material because it could have substantially affected the efforts of the defense to impeach DT, thereby calling into question the fairness of the ultimate verdict. The prosecution itself viewed DT as an essential witness, so much so that they went to these dramatic lengths to secure his testimony from across states. And it's understandable because he was the only witness who could directly corroborate any of CG's allegations. With no physical evidence and no eye or ear witnesses to the charged incident, the prosecution really turned on whether the jury could believe CG's claims beyond a reasonable doubt. CG's corroboration made it much easier to credit CG's account of the abusive phone call. And if CG was telling the truth about that incident, it was much easier for the jury to credit him about every other allegation, despite the defense's explanations for all of the other corroborative evidence the prosecution put forward. The evidence of DT's bias to curry favor would have helped to counter that because it would have given teeth to the defense argument that DT was not testifying to his own memory, but rather to what he had heard from CG or from the police. We can't be confident that a jury that heard evidence that DT was biased to curry favor with the prosecution would have credited DT. And without DT's corroboration, we can't be confident that the jury would have overcome the reasons to doubt CG's account of the charged incident. Basically,
you think that we can't be confident of that, even though 2 years before the material witness warrant issued, DT testified in the grand jury essentially the same way that he testified at trial?
I think that's right, because the revelations about how long and how vigorously the prosecutor pursued testimony from DT up to and engaging this interstate process really cast the entirety of his testimony in such a different light as to undermine confidence in the verdict. They depict a kid.
Well, if you subtract the issuance of the material witness warrant and jailing of DT's father, what does the record clearly show about what you claim are biasing activities?
Well, I think the evidence would have shown that DT was feeling pressured or could have been feeling pressured by the prosecutor's, increasingly intrusive tactics to get him to testify both in the grand jury and at trial.
Well, I'd like you to be specific because it strikes me that the mere fact that DT knows that the prosecutors want him to come and testify, and DT doesn't particularly want to, if that's true, or is afraid to, that is not biasing. That does not strike me as, in and of itself, um, evidence of bias. Well, it's evidence of bias in favor of your client, not against them. But so I don't understand. That's why I'm focusing on the fact that, I mean, put it this way. I'm focusing on the fact that the bias theory is that the jailing of his father,
Mhm.
and that overwhelming display of force from thousands of miles away that you just, effectively described, resulted in affecting DT's testimony in a biased way, biasing DT, affecting his testimony. And it seems to me that's a hard sell, or at least a problem with that argument that you have to overcome, is that the record shows it didn't affect his testimony, because he testified to the same thing two years earlier. Now, I understand you could point to slight wording differences and so forth, but it seems to me it's substantially the same thing. And your job is to show that there's a reasonable likelihood of a different outcome at this trial had the biasing testimony come in. And I have trouble seeing how that could be when we have that grand jury testimony. And to say that, well, he knew that they were after him for, 2 years doesn't really seem to me to do the work that would need to be done for that argument.
Well, I just first a note on the standard, and then I want to talk about the specifics of the grand jury testimony. But it's a reasonable probability of a different outcome. It's not more likely than not. It's really this focus on, can we be confident?
If I said more likely than not, I didn't.
You didn't. No, I just wanted to sort of highlight that point, because really the focus is on, can we be confident that the trial would have come out the same way? And I think we can't, and that's because of the potential impact of the whole of this testimony. So I'm going to talk about the effect on the trial testimony first, and that's because it's relevant to coloring how the jury also would have seen the grand jury testimony. Because what we would have seen from this evidence is not only that DT had a bias and a motive to curry favor with the prosecution at the time of trial, but that also he acted on that motive, consciously or not, by changing his testimony from describing a report of touching to the grand jury to describing a report of rape at trial. That's a big difference. The jury certainly could have found that that's a big difference. And if they had known about this arrest that had happened in the interim in a way that could have easily frightened a 14-year-old kid, they might have appreciated that difference more, right? So then on top of that, you have this evidence that DT can be moved by what's been going on with the prosecutor. And then you have a lot of evidence that what was going on with the prosecutor before trial started way back before the grand jury, right? You have the prosecutor's statement to the trial court that Mr. Tyler had not been helpful for 3 years. That was going months before the grand jury. We know that Mr. Tyler was the sole caretaker, and the prosecutor's practice was to request testimony from the parent in custody. It seems unlikely that DT just happened to be in DC with his mother when the prosecution called him into the grand jury, particularly given DT's testimony that when he was first contacted by the police about this case, he was in Kentucky with his dad. And given Mr. Tyler's later complaints, which he made all in one breath, that he thought the AUSA, quote, understood that he did not want his son to testify, and, quote, that his son is scared of the courts and that he did not appreciate the United States Attorney's Office and his baby's mother sneakily having his son testify in front of a grand jury. And he was so upset about this that 8 months later, he's still yelling at the prosecutor about it. So at a minimum, I think from all of that, the jury could infer that the prosecution was acting just as doggedly before the grand jury to secure DT's testimony. And really pushing for that testimony over DT and his father's objection, acts that could reasonably lead a kid who at the time of the grand jury hadn't yet turned 12 years old to try to say what he thought the prosecutor wanted to hear. And that inference is supported.
Let me interrupt. How would you have demonstrated that DT knew all of this history of what the prosecutors had been doing? Because it seems to me, if you can't establish that, you can't ask a jury to draw inferences that it influenced DT's testimony. So how would that have happened?
From the facts I just enumerated, and also DT's father's account that he had been talking with DT at various points along the way about whether to testify at trial, combined with his complaint to the U.S. attorney that, you know, his son was scared of the courts and he didn't appreciate him being brought in to testify with the grand jury, that suggests that there had already been a dialogue between DT and his father. It's certainly enough for a well-reasoned suspicion that DT understood that he was, you know, that something was going on here. The prosecutor was working with his mom around his dad's back to have him come in for this testimony that he didn't want to give. So I think the whole
Well, that's
arc.
distinguishing. Let me just point out, it's one question whether you have a basis for a well-reasoned suspicion to go into cross-examination. The question is how much you actually could get before a jury to persuade such that you can raise a reasonable probability of a different outcome is a somewhat conceptually distinct question.
Right. Well,
This, by the way, oh, I'm sorry, I don't mean to cut you
Go
off.
ahead.
I want to come back to something. Well, all right. This raises a concern I've had about this case that I guess I should ask you about. You know, this Brady issue was originally raised on direct appeal. And this court sent back. He said, we're not going to deal with it. We want to see the motion filed in the trial court so that a suitable record could be compiled for appellate review. And yet, there was no evidentiary hearing on this motion. And you have not claimed on appeal that the trial court erred in ruling on the motion without holding an evidentiary hearing. I have to confess that don't you think it's difficult for us to evaluate the materiality here, maybe impossible to evaluate the materiality here without having actually had an evidentiary hearing on all these issues and to see exactly whether this claim of potential bias actually panned out? I mean, you're asking a lot, you know, to say, let's bring back all the witnesses, let's throw out this trial, call this child or children again to the witness stand for a trial when we're really in a rather ignorant state because we didn't even bother to have an evidentiary hearing to see whether there's much to this or not. That's a separate point from the other concerns about whether this record shows, but it's a bothersome one to me, and I'd like to hear your reaction to it.
I'm glad you asked, because there are a number of sort of important points bound up in that question. And you know, the state of ignorance that we are all in now is a result of the suppression that prevented the prosecution from ever conducting this cross-examination in the first place. So because of that, I'm gonna say in a minute that I think the Van Arsdale presumption of the full damaging potential of the cross-examination must apply here. But before that,
that's quite right. I don't think that's quite right. Under Brady, my understanding is that the burden of proving a reasonable proving materiality is on the movement. I don't think you get the benefit of presumptions the way you would under other circumstances. Am I
think
wrong about that?
I agree that the burden of showing a reasonable probability of a different outcome is on the defense. There's no question about that. But the rationale for the Van Arsdale presumption is the nature of the omitted cross-examination evidence, not the standard of harm against which that omission is measured. So that's why this court applied that Van Arsdale presumption, for example, in Moore, which was a non-constitutional cross-examination claim. When you're trying to evaluate the likelihood that a trial could have come out differently if the defense had been able to conduct a particular cross-examination, there's no way to know after the fact how that cross-examination would have gone, what the witness would have said, what her demeanor would have been.
Well, there is. You could have had an evidentiary hearing and put the child on the stand and do the examination.
Actually, that wouldn't have answered the question of how it would have gone, and it would have resulted in the judge usurping the jury's function. It wouldn't have told us what DT says today in front of a judge in a 23-110 hearing. Doesn't indicate what he would have said years ago at trial if he had been confronted on the stand with this information of these facts suggesting a reason to curry favor with the prosecution. It doesn't indicate how he would have said it. I mean, he's years older, he's an adult now, a lot of time has passed. We can't replicate what his demeanor would have been at the time. And it doesn't say how it would have landed with the jury. And it's not.
Well, we could have learned, though, for example, whether he knew about the arrest of his father and all these efforts with respect to his father. So some things we might have learned.
He could have answered whether he knew, but it was for the jury and not the trial judge at a 23-110 hearing to assess whether those answers were truthful or accurate. This court has said repeatedly that, demeanor is part of a cross-examination. The Supreme Court said it too, that, part of your right to confrontation is not only to get the answers from the witness, but also to have the jury assess their demeanor. And a jury watching DT confronted with this evidence of his father's arrest and all of the other circumstances surrounding it, even if he said, "Oh, I didn't know about that," could have looked to the same facts I've cited to the court about, how DT lived with his father, he was his sole custodian, the father was gone for 5 days over a holiday weekend, et cetera, and concluded, I don't believe that, right? I don't believe DT when he said he didn't know. I think that that's the bias operating here. And whether the judge would have reached that same conclusion or not is neither here nor there for purposes of both the question of whether the defense would have been allowed to use this information and the question of whether it would have been material. And that, again, is why I say the Van Arsdale presumption makes sense to apply here, because, it's the nature of this kind of cross-examination that didn't happen. We can't know what it would have been. So we have to assume it would have been as good as it could be. And that's entirely consistent with the Brady materiality standards focus on undermining confidence in the outcome of the trial. The question is how the suppressed evidence would have played to the jury. And so it would be completely incongruous to expect the defense or require the defense to persuade a judge that it would have played out in the defense's favor.
Did I hear you say earlier that you had a case in which the Van Arsdale presumption was invoked in connection with a Brady claim? I didn't quite catch how you put that, but
there's a case out of Texas. So I mentioned this court's case in Moore, which applied the Van Arsdale presumption outside of the confrontation clause context. That was an evidentiary claim that evidence of a prior bad act bearing on veracity had been the defense had not been allowed to examine that.
That's not a Brady claim.
That's not a Brady claim. That's right. We cited in our briefs a case out of Texas, Crawford, that applied this Van Arsdale presumption in a Brady circumstance. So in that case, there was the trial court was required to in camera review a confidential crime report to see if it contained exculpatory information, and if so, to disclose that information to the defense. That wasn't done. The crime report was destroyed in the interim. And the Texas court said, because we're dealing here with evidence, that didn't come out, the absence of the evidence, we should apply this Van Arsdale presumption and assume the full damaging potential. And we can't even do that because we don't know what was in the report. So it could have contained Brady, and we're not going to require the defense to prove that it did contain Brady in order to find that there was a due process violation here. So that's sort of a
intuitively that sounds. Well, I haven't read the case, so I won't comment on that. I'm having a little trouble following that reasoning.
It's not a direct Brady claim. It's a little bit Brady adjacent. But I think the same instinct applies of when it's the defense who's been disadvantaged by the non-disclosure of potentially impeaching or exculpatory information. it would be inappropriate to then put the burden on the defense to prove how that information would have played out before the jury.
I
So
thought that was, it's funny because I thought, well, a lot depends, I suppose, on exactly how you frame it, but I thought the whole point is that the defense has to show in a Brady context that there is a reasonable likelihood that this evidence would have made a difference at this trial.
right. So I think what we would have to show is that, or what we do have to show, right, is that the evidence is favorable. That is, it could have been used to support a bias cross. And that if we had done that bias cross, there's a reasonable probability of a different outcome. That is, we can't be confident that the jury would have credited DT if it had heard this information. And whether a judge credits DT or not, years later, based on whatever he might say at an evidentiary hearing, doesn't answer that question. I mean, this focus on whether we can be confident.
Well, it might or might not. Don't we have plenty of Brady cases where the witness gets on the stand and testifies to some exculpatory evidence, and the judge says, you know, a jury would find this completely incredible, this testimony, and for the following X reasons, you know, it's contradicted by this, it's whatever. And isn't that a sort of a normal facet of Brady hearings and Brady determinations?
I think that, I think the courts hear what particularly when you're talking about affirmative evidence that the defense would have, put on, for example, an alibi witness or something like that. It's a little bit of a different scenario because you can bring the witness in and see what they would have said, and then look at it in the context of the entire case, right, to see whether it's makes enough of a difference to undermine confidence. Here, there's just no way for the defense to reproduce what DT would have said at trial and how he would have said it. And it is in any event not for the judge to assess the credibility of a bias allegation like that. I think another.
By the way, may I ask you one other question?
Yeah.
And I don't know whether you're in a position to answer it. And I'm not. If you're not, you're not. That's okay. But I'm motivated by the fact that you're talking about not just we'll call it the last minute subpoena to the father, arrest as a material witness, which I assume the defense did not know of at the time of trial because it had come up so recently it was not disclosed. But you've also raised this question of all the events that had occurred prior to that, all the interactions between, on the one hand, DT and his father and the prosecutor. And I'm wondering if the record is clear or if we know whether the defense knew about those things, whether that information was actually, I'll use the word suppressed or not disclosed or unknown to the defense prior to trial. And I ask that question because it's natural to assume that the defense did its investigation prior to trial, spoke to DT, if he was willing to talk to them, spoke to DT's father, perhaps, who knows. And I wonder if some of this information, in fact, was well known or known to the defense. Now, if you can't answer that question, I'm not expecting you to disclose confidential information. But it's a question of, what one can say from the record we have.
Yeah, I actually don't know, with regard to the investigation the defense did. And I think, there's certainly nothing in the record before this court to suggest that the defense had any knowledge of what had been going on with CG. The fact that this was all done, discussed ex parte with the court. We know this now from the investigator's affidavit that was submitted in support of the material witness warrant. The government rather hasn't alleged that this would have been known to the defense. So I'm not aware of anything along those lines.
Well, you're right. I certainly don't think. I'm not suggesting that the defense knew about the material witness warrant and.
Right. I'm not. I don't have any information
to say of other stuff.
Right. Not so far.
I have to say, Ms. Terrell, that I find it kind of counterintuitive, the notion that DT would have testified in a way helpful to the government, motivated by knowledge about his father's arrest and the prosecutor's efforts to get him there. I'd have thought that upset about that, he might have decided to give the government nothing that it wanted. I mean, that just strikes me as the more natural reaction. That seemed to be Judge Noter's thinking too, and I think your opponent suggests the same. What's your response to that?
I mean, I that is one way someone could react to being brought in on a material witness warrant. But, you know, just because you're angry or upset with the prosecutor who's arrested your father to get you to testify doesn't mean you aren't also afraid of them, right? Doesn't mean you wouldn't also, you know, subjectively fear further repercussions if, you know, if they don't get the testimony that they want at this particular moment in trial. So I don't think it at all precludes this, the sort of the reasonable, plausible assumption that a witness could have the opposite reaction, right? And could say, I don't want any more of this from the prosecutor. I'm just going to say what I think I need to say to make them happy and get out of this. So I think that that is well within the, you know, sort of well-reasoned suspicion of bias, how that bias.
Yeah, I guess I don't know if I think it's plausible. Under your thinking, you know, some of this had started at the time of the grand jury testimony, and DT said what he said there, and it almost seems that having seen that that wasn't enough to get the prosecutor off the back of his father, it seems more logical to think he would not be inclined to think that giving inculpatory testimony was going to get him out of this situation. That's why it seems to me the opposite conclusion is the more intuitive, and I would say the only plausible one, though I'm not sure about that.
Well, I think that inference would be significantly undermined by the evidence that DT's testimony did get better for the prosecution after the arrest. It went from a report of a touch to a report of a rape. So I think that would support the inference very strongly that DT, you know, was impacted by the arrest of his father and was impacted in a way that, consciously or not, led him to strengthen what he was saying to benefit the prosecution. And I also think, again, we can't know exactly what DT would have said or how he would have said it. He very well could have responded in a way that either acknowledged, yes, I'm terrified of this prosecutor. She keeps messing with, you know, hassling my dad, and now she's throwing him in jail, and I just want to say what she wants to hear and get out of here. It's entirely possible he would have said that. Or if not, that something in his demeanor, the way he answered questions about this, would have persuaded the jury or given them reason to believe that he's intimidated here and he's trying to say what he thinks the prosecution wants to hear. So I don't think this court can dismiss the possibility that that this cross-examination would have played out to discredit DT's testimony, and that is a reasonable probability of a different outcome, right? That does undermine confidence in the outcome of the trial, because without DT corroborating CG's account of this abusive phone call, none of CG's many claims of abuse have any direct corroboration. So this was just a critical piece of evidence for the government, as demonstrated by the links that went to secure DT's testimony for trial.
Before we let you sit down for a moment and hear from the government, I just have one question I think I need to ask you. In the proceedings below, did you argue that the grand jury, did the defense argue that specifically that the grand jury testimony of DT could have been shown to have been biased?
Well, no, because we didn't have the information. We didn't have evidence of bias, right? That was the
well,
whole
that's
problem.
I think that's still an important question for me to know the answer to. Because your argument here, in effect, is to say that, well, the bias extended not only to the bias was created and existed, not only with respect to the trial testimony, because of the arrest of the father. But there was also bias that we should have been allowed to cross-examine about with respect to the grand jury testimony. That's sort of the way I've understood what you were arguing earlier. And regardless of what I may think about the merits of that claim, I'm wondering whether that was a claim that was made, sort of before this moment. In other words, in the trial court. Which
do you
I
mean
had
a
not
trial
thought it
or,
was.
I think he means before Judge Noter.
I mean, before Judge Noter. Well, if you made it a trial, that would be interesting too. But I didn't think, I have to say, I'm not aware, but I could be just unaware, that there was any claim that there was evidence that he was biased when he went into the grand jury that we should have been allowed to cross-examine him about, and it was withheld from us.
I'm just looking at our 23-110 pleading, and I take a pass on
Fair
it.
enough. Well, why don't you, if you can manage to do two things at once, which is sort of fine.
Yes,
right?
I do believe we
Why
talked
you
about
would-
the grand jury in that pleading, but let me double check and I'll tell you what I find on rebuttal.
Okay, let us hear from the government's counsel, and we'll give you a few minutes to rebuttal.
Good morning, Your Honors. May it please the court. Can you hear me, Your Honors?
Yes.
Yes. Okay,
Yes.
thank you. Catherine Kelly on behalf of the United States. Your Honors, on direct appeal, this court found the existing record was insufficient for appellate review of the Brady claim that's presented here today, and it remanded this case to the trial court for 23-110 proceedings to develop a suitable record. Appellant had a full and fair opportunity during those 23-110 proceedings to develop record evidence, and they simply didn't do it. We stand here today with the same factual record, save the new addition of the trial court's decision denying the 23-110 motion, as we did in the direct appeal, either in the record itself on direct appeal or the appendices that accompanied the parties' briefs. The existing record still remains silent on whether or not DT knew of his father's arrest on a material witness warrant, and whether or not DT knew the reason for his father's arrest. And without any sort of awareness on that topic, there's no basis to show, and appellant has failed to show, that DT had a motive to curry favor with the government at the time of his trial testimony.
May I ask you a question, by the way?
Certainly.
Procedurally, how would this work? The defense, in their motion, asked for a hearing.
Correct.
And the pleadings were filed, and Judge Nutter decided the case without a hearing and said in his order, I don't even know if there was oral argument. Was there oral argument on the motion?
I don't believe so, Your Honor.
And Judge Nutter decided the case on the papers then, and certainly without taking additional evidence, and explained in his order that he didn't think a hearing was necessary. Now, the witnesses here, I gather, are in Kentucky. Is that right?
Correct. I honestly don't know where they are today, but at that
But where
time.
they were at the time, and
Right.
we think, in Kentucky. Could a hearing have been held? Could those witnesses have been subpoenaed and come to court?
If a hearing.
In
had
other
been
words,
held-
was there any practical impediment to holding a hearing?
Not that I'm aware of, Your Honor, no. And of
Um,
course, what
Was
you
there
have
any
here.
objection to Judge Nutter about the failure to hold a hearing?
I'm sorry, I didn't hear your question, Your Honor.
Did either party object to Judge Nutter and say you can't decide this without a hearing?
I know the government didn't. I'm not aware of anything but the written request for the hearing that was in the defense paperwork in the 23-110 here. And of course, even when there is a hearing, it's perfectly feasible and correct to not hold a hearing when there isn't sufficient evidence in the record that's been developed that would create the need for a hearing. Even, for instance, when you have an ineffective assistance claim in a 23-110 motion, in order to have a hearing, you would still, if you were, for instance, claiming that defense counsel had failed to call an important witness in your case, you'd still need to put in support of that ineffective assistance claim some sort of proffer or sworn statement by the so-called missing witness in order to generate the need for hearing at all. In this case, we have no affidavits from DT or his father, nor do we even have an attorney proffer of what they would have said regarding whether or not DT knew of his father's arrest on the material witness warrant, and whether or not DT, even if he knew of his dad's arrest, whether or not DT knew the reason for it. And in addition to that, we have no information as to whether or not DT felt subjectively that he needed, because of his father's arrest, to curry favor with the government or testify in some manner. But what we do have in the record, Your Honor, is the fact that the record shows that when Mr. Tyler, DT's father, was released on bond by the district court in Kentucky following his arrest on the material witness warrant, he was released on several conditions, all of which he had fulfilled by the time DT took the stand in appellant's trial here. The conditions were that Mr. Tyler had to bring his minor son to Superior Court at 10 a.m. on December 10th, 2013. He had to contact the prosecutor to make travel arrangements, and he was required to obey any and all future subpoenas in regard to appellant's underlying prosecution. And moreover, at that time, the district court in Kentucky also appointed an attorney for Mr. Tyler, who was required to advise him of his rights and obligations in regard to the warrant and the subpoena that had been previously served for the appearance at trial. And that attorney's appointment extended to any future obligations that Mr. Tyler had in regard to appellant's prosecution. So what you have is a situation where at the time DT testified, which happened on the 11th of December, by that point, Mr. Tyler had fulfilled all his release conditions, and if there was any sort of question as to whether or not there was anything still hanging over his head, he had an attorney that he could ask questions of. And what we have again here is a material witness warrant that's one step removed from the actual person who testified as a witness at trial. And there's nothing but speculation that DT could have been afraid that his father would be rearrested, or that he could have himself been arrested due to this material witness warrant. And there's also speculation in appellant's brief that maybe DT thought that he could have been taken from his father's custody if he didn't testify in some manner that the government wanted. That's all pure speculation. And there's certainly no evidence in the record of any sort of custody battle going on with DT. And there's absolutely no record evidence of the government or anybody else ever threatening DT or his father with changing DT's custodial situation. So adding those facts to the situation that we have here, we cited at least 3 cases where other courts have determined that a material witness warrant is simply used to obtain a witness's presence at trial, and that it doesn't support the inference of bias towards the government. For instance, in the Rudd case in Kansas that we cited, the court found that there was nothing exculpatory in a witness being arrested and bond being set on a material witness warrant. Particularly in the Gregory case and then the Johnson case from Texas that we cite, both of those cases found that in Gregory there was, it was not at all convincing to the court that the material witness warrant and appellant making bond on it was going to show a prototypical form of bias at all. And both that case and the Johnson case clarified that appearing, even if you are the witness that's been arrested on the warrant, appearing on a material witness warrant is nothing like being on the stand in a situation where you have, for instance, an investigation by the government hanging over your head, or some sort of fear of your own prosecution hanging over your head, such as the Alaska versus Davis case. So it's simply, we would say, based on this record, both the development of the record has left a situation where appellant has not met its burden to show that the information about the warrant and dad's arrest was favorable information, and therefore that it was suppressed under Brady. And moreover, even assuming that the government had failed to turn over favorable information, The trial court correctly found that the defendant had failed to establish its burden to show materiality. Of course, when you're looking at materiality, you have to evaluate the undisclosed evidence in the context of the entire record. Here, the trial record doesn't support either DT being biased in favor of the government due to the arrest or material witness warrant for his father. And there was ample other evidence, not just DT. There was a number of other sources of evidence at trial, which we outline in our brief, that corroborated DT's, or rather CG, the victim's testimony in this case.
Would you refresh my memory? I'm having a memory lapse. Was anything about DT's grand jury testimony introduced at trial?
DT was cross-examined about his grand jury testimony at trial.
Yeah, okay.
And I think I need to say too, in regard to his grand jury testimony, the record shows that DT came to testify in the grand jury while he was visiting his mother in the District of Columbia on June 20th, 2011. As the prosecutor made clear in discussing the application for the material witness warrant with the trial court, at that point it was Judge Morin, she was following the standard practice of the U.S. Attorney's Office in securing DT's grand jury appearance through the mother who had physical custody of the child witness. She made that clear on the 15th of November, 2013 at page 47. So, and additionally, when you look at Investigator Crawford's affidavit, it shows that the prosecutor's first conversation with Mr. Tyler, DT's father, regarding DT's appearance in Appellant's case occurred on September 26, 2011, which is months after DT's grand jury appearance. The only thing that defense has had on about any sort of suggestion that there was contact between the prosecutor and the father before the grand jury testimony is a comment that the prosecutor made in passing in that November 15th hearing, saying that DT's father hadn't been cooperative for 3 years. That certainly isn't a comment that indicates that she was counting the precise time that there had been contact with DT's father in the U.S. Attorney's Office. And additionally, the fact that DT's father later complained, I believe it was on February 8th, 2012, which is still a year and a half before trial, that Mr. Tyler didn't appreciate the fact that the mother and the prosecutor had sneakily put DT in the grand jury. That doesn't indicate any sort of statement that Mr. Tyler was stating that at the time DT was placed in the grand jury, that it was done against Mr. Tyler's knowledge or willingness at that time. There's simply no record to indicate any sort of communication with DT's father before or at the time of the grand jury testimony. So, which brings me to the point that it was well covered in cross-examination, the fact that DT had given a prior statement in the grand jury, which was mainly consistent with what he said at trial, and also any sort of slight deviations between what he said in the grand jury and said at trial were covered well during cross-examination. The jury had the opportunity to evaluate DT's prior statement versus what he was saying in court. And in light of that, there's no basis to believe that there would have been any reasonable possibility that had the defense been able to cross-examine DT and say, the reason you're changing your testimony is because your father was arrested on material witness warrant. There's no reason to think that that sole line of questioning would have been enough to show materiality, especially given the full light of the testimony from other witnesses that supported CG's testimony. And again, with the fact that the case law that we've presented, the Gregory case, the Rudd case, the Johnson case, all make clear that a material witness warrant is really an untenable source of bias, particularly when you're trying to say that it would favor the government.
Well, it's not the warrant, it's the arrest.
the arrest.
It's the
And
jailing of the father that presumably might have an effect on the thought processes of the son.
That's correct. And my understanding is that both in the Rudd and the Gregory case, and in the Johnson case, those were all situations where the witness, and again, the witness himself or herself, was arrested on material witness warrant. So it's not just the matter that they found out there was a warrant and turned themselves in. Those were all situations where there was an arrest. And ultimately here, you don't have a situation where the defense has met its burden to develop the record during the 23-110 hearing to fill in any of the gaps that have been discussed today. The jury had before it the prior consistent statement that DT made. And we don't believe that given the totality of the evidence that came in at trial, that there's any showing of materiality here in addition to the lack of favorability. And so for all of those reasons, we would respectfully request that the court affirm the decision of the trial court in this case.
Okay. Thank you.
Thank you, Your Honor.
Ms. Terrell, you've got about 5 minutes, I think, for rebuttal.
Thank you. Just to first answer your question about the record, on the first page of our motion for relief under 23-110, we make the same argument that I'm making now, which is we say, the non-disclosure of the father's arrest deny the defense a chance to conduct what would have been a powerful cross-examination, highlighting bias to curry favor. And then we go on to say, additionally, the government's failure to disclose the jailing of the boy's father was the terminus of a failed campaign on his father's behalf to shield the boy from testifying, beginning with a subpoena to the grand jury. This would have provided further evidence to underscore the nature and extent of the boy's motive to curry favor with the government that the defense could have highlighted on cross. And that's what I'm arguing to this court today, that when taken all together, the evidence of the prosecution's pressure campaign, which there's good reason to believe began before the grand jury and culminated ultimately in the father's arrest, would have moved a young 11-year-old in the grand jury, 14-year-old in trial witness to be motivated to slant his testimony, to favor the prosecution, to get them out of his life, right? Just to get past it. The material witness warrant cases that the government relies on, again, are contrary to the extent they hold an arrest on a material witness warrant is not sufficient foundation for a bias cross. They're inconsistent with this court's binding precedent in Skull, in Blunt, in Melendez, that it is the subjective view of the witness, not what the prosecution actually can or will do that creates the bias. I mean, in Melendez, this court was reluctant to say that there could be any belief so preposterous that it wouldn't support a bias cross. And it's certainly not preposterous to think that a witness who's been arrested by the prosecution to secure their testimony would fear further consequence if the testimony is not satisfactory. I'll just note that the Rudd case, that is an unpublished case out of Kansas that the government cites. From my read of that case, it appears there was no argument that the fact of the arrest itself was biasing, but rather the defense was trying to get a hold of the affidavit accompanying the material witness warrant in order to see if it contained exculpatory information. And the other cases are sort of similarly distinguishable. The Eighth Circuit case held on the basis of harm. So despite its skeptical comments about material witness warrants, it did not make any holding on the merits of that question. There was no arrest in the Satie case, the unpublished case out of Washington. And then in Johnson, it's a 1983 case out of Texas. The argument was that the bias arose not from the arrest of the witness, but from his release without having to pay bond, his release on personal recognizance without the government objecting, so that he was somehow indebted to the government because of that release. So all of those cases are distinguishable, and in any event, contrary to this court's binding precedent. I think, there's no question that this evidence would have met the requirement of a well-reasoned suspicion to inquire into DT's bias. The grand jury was already, at best, a double-edged sword for the prosecution. That it was the defense that brought it up on cross-examination at trial to show that DT's testimony had been changing to the prosecution's benefit by the time of trial. Just think how much more powerful that information would have been if the jury had known that in the interim, the prosecutor had DT's father arrested and held for 5 days to overcome his attempt to protect his son from coming to testify at trial. So I think there was ample basis in the record for the jury to conclude that there had been a years-long pressure campaign, that DT was aware of it, that he was intimidated by it, and it just cast into doubt the veracity and reliability of his statements corroborating CG's claim of this incident of abuse, which
Does anything in the record reveal why DT was or might have been reluctant to testify?
Well,
if one said to DT, we hear you're reluctant to testify. Why? What would you have said? Do we know that?
At trial, do you mean, or currently?
Well, at any point. The premise of all this is that DT was reluctant to come and testify.
Right.
And his father was sort of standing up for him and whatever. Maybe his father was reluctant to have him come testify too. I don't know. Have we actually, has anything in the record identified the reason DT was reluctant to testify?
Well, the prosecution investigator's affidavit that supported the material witness warrant, quotes the father saying at a couple of points that DT was scared of the courts and didn't want to testify. I think that's, he didn't want to be involved with this.
But why? He was nothing more than, I know that. I knew that. I mean, nothing more than that, in other words.
And I think a jury that had the information that was suppressed here could have inferred a number of reasons why DT would not.
No, I understand. I'm just asking what we actually know.
Right.
Or what the record is. Yes. Okay.
Not least of which would have been that DT didn't want to testify because what he was saying wasn't true, or at least wasn't something he personally remembered. And that was the argument that the defense was making about DT. It lacked teeth because just as you're saying, without the suppressed evidence about how DT's testimony was secured both in the grand jury and at trial, we couldn't explain why DT would testify to something that he didn't remember. Had we been able to do so, the outcome could well have been different because DT's testimony was so important to corroborate the only one of CG's accounts of abuse that was corroborated.
And what was the basis for the claim that he was testifying to something he didn't remember?
So we argued, DT acknowledged that he did not have a good memory of this phone call when he testified at trial. And his account of the phone call differed from CG's. It was, it was a more graphic statement that CG testified to receiving over the phone than what DT heard. Although, the prosecutor argued in closing that, this was a long time ago. He wasn't taking notes on it at the time. And, it lined up in material, on the significant points that the phone call happened, right? So the defense was just arguing from those discrepancies and from DT's own admission that he didn't have a good memory, that really he didn't have any memory of this. And he was just saying something that CG had told him or that he learned from the police. What we didn't have was...
Did he say he didn't have any memory of it?
He said he didn't have a good memory of it. He did not say he had no memory of it.
Would you say that his admission that he did not have a good memory of it undercuts the argument that he's trying to curry favor with the prosecution in his testimony?
I don't think so. He did say that on cross. I think, that sort of highlights that had we been able to cross about the motive to curry favor, we might have gotten sort of more meaningful admissions from him. I don't think that admission added a lot because of the discrepancies between his testimony and that of the complainant. And I think, the government was able to say, look, he got it close enough. What we were missing was a reason why he would be making this up. Why would he be saying something he didn't remember? And the suppressed evidence would have provided exactly that. And for that reason, we just can't have confidence that the outcome of the trial would have been the same had we been provided this evidence and given the opportunity to do what could have been a powerful bias cross-examination. So for that reason, we'd ask this court to order a new trial.
Counsel, thank you very much. Case is submitted. And you both may log out.
Thank you.
We will call the third case, Cecilia Mills versus District of Columbia. Counsel, you may proceed.
Good morning, Your Honors. Omar Besiso appearing on behalf of Ms. Mills, and I would like to reserve 3 minutes for rebuttal. Okay. May it please the court. Good morning, Your Honors. The evidence in this case was wholly insufficient. The appellant was convicted of reckless driving and driving under the influence. The bulk or the majority of the court's holding seems to be focused on the fact that the vehicle in question, driven by the appellant, veered into the lane of officers that were driving on a very narrow residential street in Washington, D.C. It was established that there wasn't clear lane markings. The officers basically said that they had to stop in order to avoid an accident, and that the vehicle self-corrected and drove past them without any issue. Furthermore, they claim that after following the vehicle, they saw it make a series of turns without using her blinker. These are the factors that the court used to find the appellant guilty in the case. The issue with that is that the fact that there was no marking and the fact that we didn't really know where exactly the police were, combined with the fact that if it's a narrow street, you know, if there's traffic moving in both directions, one vehicle is going to need to stop to allow another vehicle to pass it. That does not rise to the level of reckless driving. Furthermore, with regards to the speed, there was no testimony from the officer about what the exact speed was. There was no visual estimate identifying what the speed limit was or how much faster it was. There was no radar or LiDAR result presented. It seemed to be a subjective perception of the officers that the vehicle came towards them at a higher rate of speed. But that doesn't rise to the level of reckless driving. A criminal conviction.
Is it reckless if the driver knows that she is impaired?
That could be a factor that could be considered. I don't believe that that's what happened in this case. I think that when the court's just looking at the driving behavior and what actually happened, all we have is something that's typical in the district. If it's a tight, narrow street with cars parked on both sides and there's no clear lane marking, then surely anybody who gets onto that street, you know, somebody has to stop first.
Well, I have the impression that the trial court found that Ms. Mills was going at an excessive rate of speed when she made the turn into the street. Is that accurate?
Yeah, so the precise testimony that's supported by the record was that the officer said it was a higher speed, but he didn't specifically say how much higher. He just indicated that from his subjective viewpoint, it was a higher rate of speed than normal, but no speed limit.
And I also have the impression that the officer said that in the way in which Ms. Mills was driving and making turns, she appeared to be either hitting or coming very close to be hitting some of the parked vehicles. Is that accurate?
Your Honor, I believe that my understanding of the facts is a little bit different in the sense that the officer is claiming that she parallel parked her car very quickly. She went in nose first, and she did it so quickly that he thought that there could have been damage, but there actually wasn't any damage. So we don't know what viewpoint he was looking at. From what angle did he view this that he thought that there was an accident? Surely when anybody parallel parks their car, by nature of parallel parking, you're going to get very close to other vehicles. That's just how parking works, especially if it's, you're trying to fit into a tighter spot. But there was no damage. There was no accident. She was able to competently and successfully park the vehicle quickly without causing any damage to the cars in front of her or behind her. So I don't believe that that's a factor. And in regards to the turns, the testimony was also that the traffic was very light. There wasn't testimony that there were many cars around. It wasn't clear how far their vehicle was with regards to her vehicle, so that she needed to use her signals. There was no testimony that there were many pedestrians in the area. So none of those factors were there. In fact, it was acknowledged that there wasn't a lot of traffic at that time. So what
You
we're left
have said a couple of times that the evidence did not suffice to show that she was driving recklessly. And of course, the statute it talks about guilt of reckless driving and then sets out some other words. There's one phrase that says without due caution and circumspection. Do you think the evidence was sufficient to show that she drove without due caution and circumspection?
No, Your Honor, I don't. I believe that it might not have been ideal driving behavior. If we're taking that the officer says, well, look, it was a higher rate of speed, it may not have been ideal. I don't believe it rises to the level that makes it reckless as intended by the statute. And, when we look at some of the case law in the district, one case is the Kennedy case, where the police said it was 45 miles per hour in a 25 mile per hour zone. It looked like the person was racing. There were people around because a nearby club had closed. So they're taking into account, what's going on in the area. And that's the type of case. I mean, you're racing, they're running a stop sign. Here, what we have is something that I would submit to the court is fairly typical in cities and in areas where the streets are narrow and there aren't clear lane markings, which is that people have to stop in order to avoid a collision. In this case, she immediately realized her mistake and self-corrected and proceeded without any issue.
Well, I'm going to focus your attention on the language again, as I'm trying to figure out which adverbs or whether the adverbs carelessly and heedlessly apply just to the language that immediately follows, which is in willful or wanton disregard for the rights or safety of others, or whether carelessly and heedlessly also applies to without due caution and circumspection and at a speed or in a manner so as to endanger or be likely to endanger a person or property. How do you read this language? A person just guilty of reckless driving if the person drives a vehicle upon a highway. That has to apply to everything. It's kind of the subject of it all. But then the next phrase is carelessly and heedlessly and willful or wanton disregard for the rights or safety of others. And my question is, does the carelessly and heedlessly apply just to that first clause, or does it also apply to without due caution and circumspection and at a speed or in a manner as to endanger or to be likely to endanger a person or property? What do you think?
I think they could be read as separate or referring to the same thing. But I think that the gist of what that's saying is that when a person drives in such a severe manner that they use the word wanton, willful, they're doing it in such a way that they're likely to endanger other people through the severity of the behavior. So the best way for me to explain that to the court is, imagine if we had similar facts, but there was a clear lane demarking. And there was clear lanes and the street was broader and a vehicle at a high rate of speed almost veers into somebody who's clearly within their lane. I think that's what would be considered more wanton or willful, or as that's a higher level of carelessness. But simply proceeding onto a street that doesn't really have the clear lane markings, we don't exactly know where the officers were. I don't think that rises to such a level that's intended to be meant by the statute. And that's why I often, really look to what cases we have where evidence has been held sufficient so that we can really see what the court is intending to do. I think some of the language that Your Honor just cited can be read very broadly. And what we don't want to do is find that, essentially any traffic infraction, running a red light, failing to obey a highway sign, whatever it is, could potentially put other people in danger, could be considered a form of carelessness.
Under which prong of the statute do you understand Ms. Mills was found guilty?
I don't believe it's immediately clear which section the judge was referring to. The judge did cite the entirety of the statute, and she did did the jury instruction. But if the theory is that it was carelessness and without due circumspection to other drivers, well, we do have to note that the evidence did establish that there weren't that many drivers on the street. There wasn't that much traffic at the time, and there wasn't.
When the case was reviewed by the Superior Court judge, do you have an understanding as to which prong of the statute the Superior Court judge, Judge Pasachow, upheld the conviction?
Yes, Your Honor, I do have that. She notes in that driving in a manner that's likely to endanger a person or property. The defendant's abrupt parallel parking came close enough to hitting another car, is what she noted in her finding, Your Honor. So the court would basically emphasize that you don't have to have actual damage, but as I said, in this case, the fact that she parked successfully without causing damage doesn't mean that she likely endangered person or property. We don't know the angle or viewpoint of the officers when they saw her.
So if I understand you correctly, your answer to my question is you think that Judge Pasachow upheld the conviction under the second prong of the statute. Is that right?
That's correct.
And not the first prong. Is that right?
Yes, Your Honor.
Okay. Now, what do you understand the word heedlessly to mean? Do you understand heedlessly as a synonym for negligently?
I believe that it's probably a higher standard than that. It's something that's a little more egregious to the point where it really endangers other traffic or pedestrians. So
if you're correct about that, well, I don't mean to interrupt you if you want to give me more about what you think that higher standard is. So.
Yes, Your Honor. I believe so. In criminal cases that involve reckless driving, the court's looking at a lot of factors that indicate a person is really disregarding the health and safety of the people that, of people on the street, of pedestrians, of other cars. It's not meant to, based on my understanding, just affect, apply to any infraction. I mean, these traffic infractions regulations exist because essentially any violation could put other drivers in danger. That's why they exist. But when we look at the statute and what's required in terms of how wanton and reckless the driving behavior is, they're looking at a lot of factors that indicate a substantial likelihood that somebody is going to get injured, or you're driving in such a way that you're very likely to cause an accident and damage property. You don't have to cause the accident. There doesn't have to be actual damage, but that's kind of how the courts have dealt with it.
Do you understand the trial judge or that is to say the magistrate judge or the Superior Court reviewing judge, do you understand that either of them found more than simple negligence? In other words, you think heedlessness requires more than simple negligence. Do you understand that either of them found more than simple negligence?
I believe that they did give a lot of weight to the fact that some of the officers' testimony was that the driving was erratic, and they gave weight to the issue with the turn signals. And my understanding of what they're essentially saying is that it did rise to a level that met the language of the statute based on those factors. And what I'm saying is those factors are not sufficient to rise to that level, because they really are. There is some dispute about whether there was a violation if there weren't any cars behind her when she did the turns. We don't know how far the police cruiser was, and the evidence was clear that there was not a lot of traffic at that time or pedestrians. So, Your Honor, if I may continue, did the court I would like to address the driving under the influence charge as well.
You may.
The court did find her guilty of driving under the influence. The majority of the court's opinions was based on the fact that, she was described as not giving the correct answer. She was asked what her social security number was. She provided the first 5 digits. The court took into account some of the driving. They took into account that she used the vehicle to assist herself when she was walking. But notably in this case, there was no breath or blood test. There was no urine test. And furthermore, there was no field sobriety test administered. In addition, the court discusses in its holding that in many cases, these factors, bloodshot, glossy eyes, a person not cooperating fully, odor of alcohol are often used as circumstantial evidence to build the case. But notably in this case, there was no odor of alcohol. The officers were close to her. They were interacting with her closely. They were giving her sort of contradictory commands. In the transcript, it turns out that she parked in front of her house. She explains to them repeatedly, I need to use the restroom. They tell her we were trying to get her to give us her driver's license, but she told them repeatedly that my driver's license is inside the house. So, the officers were saying, well, she wasn't, we were telling her to stay in the vehicle. She wanted to get out. You're asking her for her license. She's made clear that her license is in the house. That's one of the factors. In addition, again, there was no breath or blood test. There was no nexus or connection to anything that involves alcohol. In many cases, as we look at the annotated cases that involve the sufficiency of the evidence in a DUI case, we see an order of alcohol. We see admissions. We see circumstantial. I was coming back from a bar. The defendant said he was coming back from a bar and he had a few beers. I would submit to the court, it's very difficult for me to find any case in the district where someone was found guilty without even, what is the causal connection between under the influence and the observations? What is there here that involves anything to do with alcohol? Did they find an open container? They did not. Officers sometimes will approach a vehicle, though they can smell marijuana. They can smell PCP. They know these things that could affect the driving behavior. So we have an odor, we have something. There's something somewhere. And in this record, we don't have that. There is no odor. There is no, of course, they don't have to have a chemical result, but there was no chemical result provided to overcome that. There was no urine result. There was no odor. There was no admissions. Evidence established that she's 68 years old and she wanted to go inside the house. She parked right in front of her house. She successfully parked. She didn't have issues with that. She did not cause a collision. She was cooperative to the best of her ability. Yes, sometimes people forget, a social security number, things like that, but that doesn't mean that she's under the influence. So under this record, what can we say says she's under the influence because there's some circumstantial evidence relating to some substance? There's nothing here. There's no explanation for that. So our argument is that based on the very limited evidence in the DUI case, the fact that there was no admissions or nothing linking any of the observations, those observations could be explained by other things. They could be explained by a medical condition, a trauma, exhaustion. Does that make it under it? I don't believe that makes it under the influence, Your Honors. And thus, the evidence was wholly insufficient also to find her guilty of driving under the influence.
The court's comments during the sentencing portion of the proceeding show that the court also presided at a couple of other DUI cases involving your client. You don't say this or suggest this in your brief, but do you think that the court's verdict on the DUI charge was influenced by what the court knew of your defendant from those other cases? Because you're right, there's no evidence of, no direct evidence of alcohol here. There's no open container, no smell of alcohol, no testimony about coming from a bar, any of those things you mentioned. What do you think?
Your Honor, I think that's very possible. I would just submit that, judges are human beings and what they know about something could, I believe that in most cases, judges do their best to rule on the law and the facts and the evidence. Having that fact known to a judge could possibly be a factor. But I really want to emphasize to the court that there's just nothing really here to do with alcohol. And my test, and I believe what should be the court's test, is how is a defendant determined that they're under the influence if we can't even point to anything saying what that substance was? Sure, it's established. You don't need a breath test. It's established we can use circumstantial evidence. We're not going to argue against those things, but what is the explanation when somebody's found guilty of driving under the influence and we can't say what that substance is? We can't say, look, yeah, there was no open container. There was no odor. There was no admissions. There's nothing here to do with alcohol, nothing. And that's the core issue with this case. If the court's knowledge of a prior case could have affected that, that's something that's possible.
Okay.
You have not renewed your argument about the body-worn camera footage, and I see you're out of time, but I did want to ask you this question. The trial court in ruling on that issue mentioned that the police officer whose body-worn camera picked up something in the hospital was there as a sentinel, was the word she used. What did you understand her to mean by that? Do you remember that? This was not an officer who arrested your client on the scene for reckless driving, but someone who was at the hospital in some capacity, and the trial court said, use the word sentinel. Did that have some meaning to you, or does it have some relevance to the issue of whether or not the government had an obligation to preserve the footage from that officer's camera?
If it's meant as a way to absolve the government of their duty to say, like, look, there's less connection here between people who are directly involved, like officers and someone else, then that's how that could be interpreted. We really took issue with the fact that, not that the court didn't dismiss the case entirely, but that they didn't put any sanction at all. And I think what it relates to, Your Honor, is the fact that the evidence in this case is already so limited. Had there been stronger evidence, had there been a breath test or something more than that, a urine, an admission, an open container, an odor, then I think the calculation might have been different. But the fact that there was no sanction in a case where the evidence is so limited and so little connection, so little nexus to alcohol, I think that's what the issue was, that no sanction at all was really put, not necessarily that the case wasn't dismissed in its entirety. So I do believe that that was an error. There could have been an inference that, for example, the video that showed her at the hospital showed what she's naturally like 3 hours later. If she appeared the same way 3 hours later as she did at the time of the stop, maybe that's her natural disposition. Maybe that's just how she looks, talks, acts. These factors are critical. These are criminal cases where, the evidence can be insufficient, and we need to know what happened, especially in these DUI cases where we don't have a blood result. If we're relying on these factors, the defense should have access to that.
Okay, well, thank you. We will give you a few minutes in rebuttal. Let us hear from counsel for the government.
Thank you, Your Honor.
Mr. Martorano.
Good morning, Your Honors, and may it please the court. John Martorano on behalf of the District of Columbia. The evidence was sufficient to support both convictions in this case, and the trial court's refusal to impose a sanction was not an abuse of discretion. I'd like to start off with the two ways that you can violate this statute. And this comes from the Murray versus District of Columbia case, that there's the first prong with the carelessly and heedlessly, and then there's the second prong, which requires without due caution, circumspection, and at a speed or in a manner so as to endanger or likely to endanger persons or property. And that, Judge Thompson, the carelessly and heedlessly only modifies that first clause based on what Murray has said. And without due caution means how other people would drive under the circumstances. And let's take a look at the facts, which are reviewed by this court for clear error, as to what met that standard. She veered into the cruiser's lane, and the officers braced themselves because they thought that they were going to get hit. She was driving with one headlight at night. She drove at what the officer said was a relatively higher rate of speed. It was a congested road with parked cars on both sides. She made 4 turns with no signal. She came close to hitting cars when she was on Holbrook. She almost hit a parked car when she abruptly parallel parked. And all of these things, as Kennedy versus the District of Columbia says, the court has to consider the totality of the circumstances. They don't just view each one of these factors in a vacuum. And the totality here shows that she drove without due caution and circumspection, and at a manner that was likely to endanger both the officers and the cars, was the testimony. And going to Judge Glickman's question about whether the due caution and circumspection prong requires a higher standard of negligence, I agree with my colleague that it does require a higher standard. It's negligence plus. So it's without due caution is what a similar person would do under the same circumstances. And then there has to be the additional element that it was at a speed or in a manner likely to endanger or did endanger persons or property.
Let me ask you, if I may, you take the position that the word heedlessly does not apply to that second prong. How do you respond to the argument that the word heedlessly modifies the word drives, or and that the second prong and that the word drives applies to the second prong as well as the first prong? That is to say, if you don't insert the word drives in the second prong, it doesn't mean anything. So that's an argument that heedlessly applies to the second prong as well.
Two responses, Your Honor. Carelessly and heedlessly, if you look at the way the statute is set up, there's a comma that comes after this disregard of the safety of others. Murray versus District of Columbia says that the second way is just without due caution, and I don't read heedlessly to apply to that second standard, because without due caution and circumspection is a negligent standard versus something that's heedlessly, which this court has said it's higher than negligence and almost to the point of recklessly, but it has an element of a disregard for the safety or rights of other people. And you can find that, Your Honor, I know it doesn't have presidential value, but it's Reed versus the United States. It's an unpublished MOJ. It's 17 CF 1806, and specifically footnote 6 that talks about how the two ways you can violate the statute, and that there's a negligence plus under that second prong. And so when we look at that—
Hold on one sec. What does negligence, well, I take it you mean negligence plus means negligence plus at a speed or in a manner. I mean, I want to focus on what the plus is. At a speed or in a manner so as to endanger or be likely to endanger a person or property. That's the plus?
Yes, Your Honor, that's the plus.
And does this equate to what we normally think of as recklessness being conscious disregard of a known serious danger? Or do you
not
think
in the
it's
second one, Your Honor?
Not in the second prong.
Not in the second prong, no, Your Honor. That's the second prong is associated with the negligence plus the speed and the manner, and likely to endanger others or did endanger others. The recklessness is really in the first part of the first prong there.
So that's interesting. So, I'm sorry, go ahead. I didn't.
No, go ahead, Your Honor. Go ahead.
Well, what I'm hearing you say, and I'm not saying I take a position on this, what I'm hearing you say is that you have two different mens reas in this statute, depending on which prong we're under. A recklessness mens rea for the first prong and something less than a recklessness mens rea. I don't know whether it's gross negligence or whether it's negligence in doing something. It's a little unclear to me what it is. For the second prong, is that what it comes down to? Two different mens reas in the statute, one for each prong?
I believe it does, Your Honor. And the reason I say that is because the legislature, there's nothing that hamstrings a legislature to prescribe reckless conduct in a reckless statute. They can prescribe negligent conduct as under a reckless driving statute, but this isn't just simply negligence based on the reading of the statute. You have to have that negligence, and you also have to have a speed or a manner so as to endanger or likely to endanger the other person. So that's the way I read that second clause, Your Honor. So to answer your question, it's really a negligence plus, and it does actually prescribe two different standards of mens rea there. But they're both sufficient.
And to be certain, to be sure, I do grasp this point. Heedlessly is an adjective, is an adverb that does not apply to the second prong, in your view. It only applies to the first prong.
That's right, Your Honor, because heedlessly, as I said, and as this court noted in the Reed case, that it's a disregard for the rights of others. And we don't see that type of language in the second prong of the statute. So it would seem like that would only apply to the first prong of that statute.
But if that's what heedlessly refers to, why was it necessary in the statute to follow that with in willful or wanton disregard for the rights or safety of others? Doesn't that become duplicative? I mean, as Judge Glickman points out, it seems that heedlessly is an adverb that modifies drives. So really, it sounds like the language works like this: drives a vehicle upon a highway carelessly and heedlessly. Item number one, in willful or wanton disregard, or item number two, without due caution and circumspection, etc., so that heedlessly applies to both. I guess you're telling us that we said otherwise in Murray. Is that what you're saying?
Yes, ma'am. Yes, Your Honor, that I mean, Murray clearly, it was a jury instruction case where the jury was instructed on one way to violate the statute, and they came back and the government offered evidence on the other way. And so the heedlessly, I believe, there has to really apply to that first prong of the statute, and not the second prong, because it would be, I think it would also it would conflict with the two different mens reas, as Judge Glickman pointed out. And I just want to point out that there was a relatively higher rate of speed. That's the way the officer characterized it. But I would like the court to focus on the manner that she almost hit these officers. She almost crashed into these officers. They braced themselves. They had to hit their brakes. And there's testimony from Officer Berg in the record on page 42 of the transcript that there was actually enough room for those two cars to pass through the road. And so she veered into the officer's lane head on with one headlight and it was at nighttime. And that to me, when you have that kind of driving, if you look at the municipal regulations, Your Honors, for traffic, if you look at 18 DCMR 2200.2, it's failure to use reasonable and prudent speed on a roadway regarding hazards then existing. Now, she wasn't issued an NOI for that, but you can certainly see that the parked cars were a hazard, then existing at the time. And there's also another regulation, Your Honor, in that same municipal reg, 2200.5, that says failed to reduce the rate of speed on a narrow street. I mean, it's undisputed that this was a narrow street, and the officer said relatively higher rate of speed. So he's not trying to quantify the rate of speed. What he's saying is this was just without due caution and circumspection, and she almost hit us.
Well, it's helpful that you mention these regulations, because it seems that if the issue before us were, should she have gotten a ticket? Maybe the answer is yes, absolutely. She should have gotten a ticket. This violated these DCMR provisions that you mentioned. But I think as it happened, she didn't hit the police officer's car. And it appears she didn't hit any other cars either, although they thought she had initially. And what I'm trying to figure out is how we can distinguish this second part of the statute from, say, a fender bender. Let's say I'm driving along and I look over at my cell phone, which I shouldn't be doing. And so I run into the car in front of me and there's a fender bender. There is damage to property. There is actual damage to property. What's likely to happen based on general experience is I'm going to get a ticket when the police come. But I doubt I'm going to be charged with reckless driving, or at least it doesn't seem that most people in that situation are. What's the difference? What's the difference between the kind of negligence that satisfies without due caution and circumspection, et cetera, and the ordinary fender bender case when the driver is distracted?
Well, Your Honor, the difference between that situation and this situation is that she did this conduct right in front of the police officers. That's the first distinction. The second distinction is that you have to look like footnote 3 in Kennedy versus the District of Columbia says. It says you don't look at these things in a vacuum. You don't consider just the one thing. You consider it all. But I submit to the court that the due circumspection in that circumstance on a congested street would require her to slow the speed down. And if she veers into somebody else's lane, that is the act that is likely to endanger the persons or property. And that's my answer, Your Honor. I think the likely to endanger, were in your hypothetical, you said, they did smash into the car in front of you. Here, you've got a course of conduct that it's not just the endangering of the officers, it was the endangering of veering into the lane and endangering the officers there, but then it's, 4 turns without a signal. It's one of the officers on page 47, 48 of the transcript says she came so close to those parked cars on the opposite side of Holbrook Street, and that when she pulled into the parking spot head first, that was, abrupt, and we thought she might have hit that car. And so if we're looking at that, that's also a violation, Your Honor. If you look at 18 DCMR 2221.2, it's the failure to back in when parallel parking between 2 cars. You're not supposed to go head first. So we have a multitude of violations here. And this is, different from a circumstance that Your Honor described in the just failure to pay care and attention. And I see that my time is up.
I'd like to ask you another question, though, if I may.
Yes.
Assume that the evidence is sufficient to show what you called negligence plus for a violation of that second prong. Would you also argue that the evidence was sufficient to show heedlessness in violation of the second prong? If heedless, and I'm not taking a position on this with you, but if heedless applies to the second prong, this gets into a question, of course, of what heedless means. But I just want to know what your position is and what you think on that score, and why.
Well, Your Honor, using this court's definition of what heedless means, the court has said before that it's just short of recklessness. And so
where have we said that?
You said that again, it doesn't have precedential value, but it's Reed versus the United States.
This is the unpublished MOJ. Let me make sure I got that. 17 CF 806.
1306, sir.
1306. Ah.
Yes, sir. Yes, sir. Yes, Your
Now,
Honor.
of course, it's an unpublished, non-precedential opinion.
That's correct, but it's got the reasoning in it is persuasive here, and the court can look to that. But to answer Your Honor's question, yeah, I think I would answer the question yes, that if heedlessly did apply to the second part of this prong, that this type of driving really just, she had no regard for the officers, because she almost hit that car by veering into them head on a narrow street where she should have been reducing her speed, not going at a higher rate of speed.
And do you think this turns it all on whether she was in fact driving while under the influence? In other words, suppose all the facts were the same as far as the actions and so forth, but there was no evidence that she was under the influence. Would you still say that? Or does the proof of recklessness, or heedlessness, turn on, in part, on the fact that she was impaired?
No, Your Honor. The conviction on reckless driving turns on the driving itself.
On the driving, oh, okay.
On the driving itself, and she would still be convicted had she not been under the influence. I mean, I think you can look at the under the influence as sort of an aggravating factor, but even if you took the under the influence out, she'd still be convicted of, likely to, operating negligently, so as to endanger, or likely to endanger both the police officer's car, the parked cars on the road, the parked car that she tried to pull in head first when she parallel parked.
Before you sit down, do you want to say a few words? I'm sorry.
Oh, could I just ask this? Mr. Basiso points out that he hasn't found a case where there was a DUI conviction upheld where there was no direct evidence of alcohol. No open container, no smell of alcohol, no admission to having come from a bar. Under those circumstances, was the evidence sufficient to uphold the DUI conviction?
Yes, Your Honor. Because this court held in Harris versus District of Columbia 601 A2D at 21, and you can find it pinpoint site at 24-25, that this is a lay opinion, for intoxication. And you have one officer on page 48, Officer Berg, concluding that the intoxication and the intoxicative effects were from alcohol, and you have Officer Earhart testifying that it was it was an alcohol or drug of some substance. So he doesn't make a decision on that, but you did have evidence of a lay opinion for alcohol intoxication. And we don't have to prove the nature of the substance because we in the District of Columbia try to penalize and deter all impaired driving. As Justice Clark said in Bright versus Bart versus Abraham, it's the slaughter on our highways, most of which can be avoidable, now only reaches the level of those found on the battlefield. So we really are trying to deter the driving here. And the policy of the statute is to prevent any type of impaired driving. And that is why it's similar to—
Well, that's not quite correct. I mean, I think Mr. Basiso's point is that there's no evidence, or his extended point might be, that there's no evidence that Ms. Mills was impaired, intoxicated by any substance, by having ingested any substance. This could just be a health problem or her natural state or some variant thereof, for which she presumably would not be guilty under the statute. How do you respond to that?
Two points, Your Honor. First, there was no evidence in the record at all that this was her natural state. I can direct the court or invite the court's attention to where there was no medical assistance She didn't ask for medical assistance on the scene. That's page 32 and page 47 of the transcript. And she didn't ask for a cane on page 34 and page 47 of the transcript. So there really was absolutely no evidence of her, this being her natural state. But Your Honor, as the court said in Pool Night, coincidences happen, but a conclusion not based on happenstance also often has the ring of truth. And if you look here, you've got not just the erratic driving. She didn't follow officer orders to stay in the car. She could not maintain balance and she was hanging on the side of the vehicle. She had slow reaction. She was unresponsive. She couldn't give social security numbers. She had a blank stare. She had slurred speech. She was unable to stand without assistance. She never produced a license despite being asked several times to do so. She ultimately handed the court papers in mail and random paperwork instead of a license, and her eyes were glossy and bloodshot. So you would have to come up with almost 10 different explanations, and that's not what Harris, viewing this in a vacuum is not what Harris instructs the court to do. They instructed it's a various accumulation of all of these factors, plus the lay opinion that she was intoxicated, is sufficient to support the conviction for DUI.
Part of the lay opinion may have reflected the fact, or at least one could argue that it reflected the fact that one of the officers had arrested Ms. Mills in an earlier incident on a DUI charge. And as I mentioned to Mr. Basiso, it seems that the trial judge presided over those cases as well. So there's this background of knowledge about Ms. Mills and alcohol use that everyone seems to have properly, I suppose, tried to keep out of this case, but may have been a factor anyway. Do you have a reaction to that?
Well, Your Honor, I don't think that's raised by the record, but I will respond and say that, using this court's own language, that trial judges are able to do the mental gymnastics of balancing what is evidence of guilt and what is evidence that's heard in sentencing. And so, Judge Brandt, very good judge, trial judge, is certainly capable of balancing the two. And there's no hint in the record here or that she did anything otherwise.
Counsel, I have one further question. Back on the subject of the trial court's decision not to impose any sanctions against the district for the destruction of the body cam film from the officer who was the quote unquote sentinel at the hospital. My question is, does the record inform us as to why appellant was at the hospital?
Not in testimony, but the prosecutor did reference, I don't have the exact site, but it's right at the beginning of the trial. She said that she was transported to the hospital for breathing issues and asthma.
Thank you.
Does the record tell us that the sentinel was there in connection with her, or was he there in some other capacity?
You can infer from the way it was described that he was detailed to the hospital, meaning that was his duty station for the evening, that it wasn't like, somebody assigned him to transport Miss Mills to the hospital. It was just that he was one of the people the officer that was stationed at the hospital that evening. That's the way the record reads to me, Your Honor.
That seems to have some bearing on whether there was a duty to preserve the body-worn camera footage for this case. What can you say about that?
Well, Your Honor, the district takes this court's instruction in Askew versus the United States very seriously. And I have to say that we did have a duty to preserve this. And it wasn't like this, and the court found this, and it was a proper exercise of discretion to run through the cotton factors and conclude the way she did, that it wasn't, bad faith or anything that would lead to an adverse inference. It was more so that it's hard to connect. It was hard because it was labeled incident no arrest. It was not connected to the particular CCN number. So pursuant to MPT General Order 302-13 H5, I think it is, it's stuff that's labeled body worn camera that's labeled incident no arrest is only preserved for 90 days. And this was destroyed pursuant to that order. And as soon as the prosecutor found it, she immediately said, oh, it's been destroyed, and didn't hide the ball. So that's, evidence on the first count. That's evidence on that first prong that there was no bad faith. And then, the judge really exercised good discretion here, because she actually heard the testimony, right, of these officers and what the guilt adduced at trial was, which is the second cotton factor. And she renders her decision after hearing that information on page 63 through 66 of the transcript, where you can see that she basically does that. And she says, well, there's little relevance to a videotape that supposedly picks Miss Mills' demeanor 3 hours after her arrest for driving under the influence, because the primary factor there is what she appeared and her characteristics were at the time of the arrest, which were, in detail described by these officers. So that was an appropriate exercise of discretion by the trial judge. And if there are no further questions, the district would ask that you affirm these convictions and find that the judge's refusal to impose a sanction was an appropriate exercise of discretion. Thank you.
Thank you. Mr. Basisa, we'll give you a few minutes in rebuttal.
Thank you, Your Honors. Your Honors, I just really want to emphasize, I'll start with the reckless driving. In addition, it was on the record that the officers thought that this was kind of a wider body car. I think that's a very relevant a fact for the court to know. I really want to reemphasize the fact there are no lane markings here. I understand the officers subjectively felt like they had to brace themselves, and that's fine, but this wasn't exactly an evidence. I'm just talking about the nature of the streets in the district. And what came out was that this is residential. There are cars parked on both sides. This is not like a clearly delineated area, and it's not quite clear where exactly the officers were. It's possible that their vehicle could have encroached more into Miss Mills' lane, because there was no marking. That's a very important factor. This is, I would submit to the court, a common occurrence that vehicles from opposing sides coming onto a narrow street, one of them has to brace and stop, otherwise there's going to be a collision. In this case, that was avoided. She immediately corrected. So I would say at worst, maybe it's an infraction. It rises to the level of an infraction. But even if we take the statute, whether we're reading it in the disjunctive, or whether it's due circumspection or on the heedless standard, it doesn't rise to the level of reckless driving. I don't
know how relevant that is, given she was in her own neighborhood here. She knew the street was narrow and she knew there were no lane markings.
That's correct, Your Honor. So I would say if it's a violation of a regulation, that could possibly take it there, but that's at worst. I don't think it rises to the level of real reckless driving, considering these factors, considering we don't have his speed, we don't know exactly where the officer's car was, and just the nature of driving in the district is going to require, quite frankly, if it's a residential neighborhood, that you stop to allow somebody to proceed. Either party's got to do it at some point. I would like to address the DUI issue, because I'm glad that counsel mentioned the pool knot case, because that's another case that involves something to do with alcohol. The defendant's breath, appearance, and condition, his breath. There was something there to say, look, what we're observing here has a connection to alcohol. I could tell by his breath. And it's common in other cases, in the Miller case as well. So in all the cases that we're looking at, there really has got to be something to make that causal relationship, to make it under the influence, versus, as the court mentioned, she went to the hospital. She had a breathing issue. We don't know. was what was witnessed that day related to a health issue? And if it's a health issue, it's surely not under the influence. They stopped her previously for a DUI. Was that coloring their perspective? Were they viewing this from the prism of someone that they suspected was intoxicated because they had a previous case with her, even though in this case they didn't smell an odor of alcohol, even though they were very close to her? At one point, officer said, oh, we tried to assist her. They were giving her conflicting commands. Give us your license, give us your license. It turns out she's parked in front of her house. She says, my license is in the house. Stay in the car, give us your license. So, you know, a lot of these factors really shed a lot of doubt. I don't believe that the evidence was anywhere near sufficient. There was no field sobriety test. None of that was conducted. These are just simple observations of a 6-year-old woman. She's indicated to them she really needs to use the bathroom. She wants to go home. My license is inside. They keep telling her, oh, we get stay in the car. She wasn't following directions. You're asking her for her license. She's telling you the license is in the house. There were no field sobriety tests. Of course, we don't have any blood, alcohol, or urine results. We have nothing connecting it to alcohol. And we cannot explain to a person why you are guilty of under the influence if we can't even identify a theory as to what was the substance. We don't even have a theory about that in this case. We just have you're under the influence because of the observations that we've seen. And we don't have an odor of alcohol. You didn't make any admissions. We didn't find an open container. There's nothing there. We don't have a blood test. We didn't smell anything. That's not acceptable. That is not guilt beyond a reasonable doubt here.
Counsel, thank you both. The case is now submitted and you may log out.
Thank you, Your Honor.
Thank you, Your Honor.
This honorable court now adjourned. Okay, let me stop the recording, Judge Glickman.